architecture of 370.
Yes.
Let's go back to it, Mullah. Notwithstanding anything in this constitution, the provisions of Article 238 shall not apply in relation to Jammu and Kashmir. That's done away with now, Mullah, because those are Part A, Part B, Part C, Part D states. Therefore, Mullah, that's over. We're not part of any of those states. The power of Parliament. Now, here, Mullah, it relates to the power of Parliament to make laws. Just kindly note that.
That's the ordinary lawmaking power.
Yes, the ordinary lawmaking power for the state shall be limited. Now, that's important. Even the lawmaking power is limited to those matters in the union list and the concurrent list. Your lordships will see state list is out because residuary power is in the state, which in consultation with the government of the state are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India as the matters with respect to which the Dominion legislature may make laws in that state. So that's that list, Manoj.
We saw the list in the morning.
The list in the morning. So it is only those that Parliament may make laws, but that also with consultation. And consultation is mentioned here itself. Doesn't have to be repeated in the proviso, it's mentioned here itself. Correct? That also has to be consultation. I'm just trying to clarify the architecture. That's with consultation. Now you come to B. Such other matter, that is again power of Parliament to make laws. Such other matters in the said list, so apart from the list that are in the instrument of accession, such other matters in the said list.
This list refers to union and concurrent list.
Yes. Only list 1 and 3.
1 and 3.
Yeah. As with the concurrence of the government. So now, Mullahs, that law has to be also with concurrence of the government. So we are dealing only with laws here. Lawmaking power. That's the first, Mullahs, limb of the argument.
That's the restriction on the lawmaking power.
That's the lawmaking power. Concurrence is mentioned here in respect of other matters, Mullahs. No proviso is required. Here, no proviso is required. Now, let's leave the explanation for the moment. The provisions of Article 1 and this article shall apply. See, the provisions of Article 1 and of this article shall apply in relation to that state. So, this is Article 1 and this Art 370. This becomes relevant for D, ultimately. Now come to D. D starts with the word. Now, D doesn't deal with laws. It deals with proclamation and orders of the president. Provisions, such of the other provisions of this. I pause here, mothers. Others excluding 1 and 370. One second, hold on. Let my lords read it. So D is, C says the provisions of Article 1 and of this article shall apply in relation to that state. And D says such of the other provisions, that is excluding 1 and 370, shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify.
No, just 1 minute. C cannot be read in isolation without reading sub clause 1. Notwithstanding anything contained in this constitution,
Correct.
the provisions of Article 1 and this article shall apply in relation to that state.
Correct.
So that means only that Article 1 and this article will apply only in relation to that.
That's all I'm saying, nothing more. Then read D.
Now D, if one reads D,
such of the other provisions.
correct.
It means 1 and 370.
As well as other than the matters in the concurrent and the union list.
That's
Correct.
That also.
That also, I agree. And 238 also.
Just 1 minute.
Reading of D.
Yes.
Whether Khanna's reading is that it will include D, C, but exclude A and B.
Cannot, Mullah.
It will. Otherwise, it'll lead
Yeah.
to a situation you are saying that 370 is a permanent article.
Mullah, we'll come to that later whether it's
1 minute,
permanent.
yes, that's your argument.
Well, I- we-
370
I
is a permanent article which cannot be undone by even with the concurrence.
Let me forget that when I made that argument.
Right now, you're just giving us the structure of the article.
Forget that what I made that argument.
That you're
It
giving
is
us the structure.
temporary.
Yes.
It is temporary on 26th of January 1950. Let's forget about anything else. It is temporary. Why? Because, Madhya, the Constituent Assembly may still choose to. So it's temporary. There's nothing wrong with that heading. Let me finish the architecture and then I'll come back. So, Malaz, I was reading such of the other provisions of the Constitution. So that is other than 1 and 370, shall and 238, shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Now you come to orders, not to laws. Provided that no such order. What order? Order under D. Colon. Read the colon, mother. Specify colon. Right? Provided that no such order which relates to the matter specified in the instrument of accession, again, mothers, of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of that state. Again, a colon. Provided further that no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence. You go to B1 and B2. So that was the law, the same template, now the orders for the rest of the provisions. Then read 2 mullahs. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision and may be taken thereon. Same template of B and D, Malak. And they can reject it. They need not confirm it. That's how you retain sovereignty, which is the instrument of accession. And if it don't retain it, it's temporary. That's why temporary. Well, I'm just trying to explain.
With the structure of 370.
Yeah.
You complete clause 3,
Yeah.
then I have one question.
Sure,
But but we'll first, you can complete, otherwise I'll be breaking your link. It's on some unrelated area, therefore.
Notwithstanding anything in the foregoing provision. So, Malad, it's notwithstanding in the beginning of the article. Please note that. Notwithstanding anything in the foregoing provisions of this article, so notwithstanding in 370, the President may by public notification declare that the article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of the Constituent Assembly shall be necessary before the President issues such a notification. So if the Constituent Assembly recommends it, namely, that we want to abrogate 370, then on that recommendation, the President will issue a notification. And this article is contained in subclause 3. Doesn't have to be in D. So that, according to me, is the architecture of 370.